Hello everyone, welcome to today's video. We will be talking about two important concepts in the company law, the Articles of Association or AOA and the rules of constructive notice. These terms might sound complicated, but I will break them into simple, easy to understand language. So let's dive right in. The Articles of Association or AOA is a document that contains the rules and regulations for internal management of a company. You can think of it as the company's rule book. It tells us how the company is supposed to run, what powers the directors have, the rights of shareholders, and even how meetings should be conducted. Now keep in mind that the AOA is different from another document called the Memorandum of Association or MOA. While the MOA sets the company's basic framework, like its name, location, the AOA is focused more on the day-to-day operations. It's like the difference between a constitution and a set of bylaws. Here's a quick look at what the AOA typically covers. First point, share capital. How shares are issued, transferred, and what rights come with them. Second point, board of directors. The powers and responsibility of the board and how directors are appointed are removed. Third point, meetings. Procedure for companies meeting including annual general meetings, AGMs. Fourth point, dividends and accounts. How profits are distributed among shareholders and how the company's finances are handled. Fifth, winding up. The process for closing the company if needed. The AO provides flexibility, meaning that the companies can tailor the rules according to their needs. However, the AOA must be in line with the Companies Act, which sets the legal boundaries. The AOA is not set in stone. It can be changed or amended, but there's a process for that. That amendments usually need a specific means at least 75% of the shareholder must approve the change. Importance of the AOA in our lives. Why is the AOA so important? Well, it protects both the company and the shareholders. It provides clarity on how the company should function and what rights everyone has. This helps prevent disputes and misunderstandings. Now that we have covered the AOA, let's talk about the rules of constructive notice. This is a legal doctrine that applies to the AOA and the MOA. Here what it means. When a company's AOA and MOA are registered with the registrar of the companies, they become the public documents. That means everyone who wants to deal with the company, such as creditors, employers, or customers, has access to those documents. The rules of constructive notice says that people dealing with the company are assumed to know that the contents of this document. In other words, they are constructively notified about the company's internal rules. So if someone enters into a contract with the company, they can't later claim ignorance of the company's AOA or MOA because it's assumed they should have read them. Impact of constructive notice. This rule is particularly important for outsiders like creditors or contractors who might do business with the company. It places the burden on them to be aware of the company's limitations and powers as set out in the AOA and MOA. For example, if a company's AOA states that only the board of directors can approve certain transactions, and someone tries to make a deal without the board's approval, they can't later argue that they didn't know about the rules. Constructive notice means that they should have known. Limitation of the rules. That said, the rule of constructive notice has been criticized for being somewhat harsh. After all, it's non-practical for everyone to read and fully understand these complex legal documents before doing business with the company. This is why many jurisdictions now have a concept called the doctrine of indoor management to balance things out. The doctrine of indoor management is an exception to the rule of constructive notice. It says that the people dealing with the company are not required to look into the company's internal workings beyond the public documents. In other words, as long as the external party is acting in good faith, they can assume that the company is not following its own rules internally. For example, if a director signs a contract on the behalf of the company, an outsider doesn't have to check whether the director actually had the authority as long as everything seems legitimate on the surface. To wrap it up, the AOA and the rules of constructive notice are key elements in understanding how companies act and how outsiders can safely do business with them. The AO governs how the company is run, while the rule of constructive notice protects the company by assuming that the outsiders are aware of its internal regulations. Thanks for watching. If you found this video helpful, don't forget to like, subscribe, and share. And if you have any questions, feel free to drop them in the comments below. See you in the next video.